This webinar will be considering an overview of enforcement orders. We'll have a look at the process and procedure for them, and we'll also look briefly at warning notices and penal notices. We'll then delve into the court's powers and the range of options that they have available to them, as well as spending some time considering the reasonable excuse test. I'll take you through amending and revoking enforcement orders, and we'll be looking at key cases and tactical considerations, with ending with some practical hints and tips that I will use throughout the webinar. Warning notices then. So please note that a warning notice is not automatically placed on child arrangements orders before December 2008. Given the time that has passed now, being nearly 14 years above, there will be very limited cases where this will apply to, but it's something to be mindful of. And certainly in the coming years, it won't be an issue anymore for practitioners. As noted on the previous slide, if there is no warning notice attached to a child arrangements order that comes before you, you can simply apply to have that attached on a C78 form. Adding or removing parties to the proceedings, Family Procedural 12.3 allows that a person who is not a party to enforcement proceedings to apply to become a party, or indeed be brought in by the court's own initiative. Applications to be joined to these proceedings must be made on the C2 form and should be accompanied with a C1A form where appropriate and necessary.